I never imagined that storing my boat and camper on my own property would land me in a 3-year legal battle that would end with an appeals court handing down a precedent-setting decision. But that's exactly what happened when Patricia Donovan decided to make my life her personal crusade. It started on a cold November morning in 2021 in Lakewood, Colorado, a suburb just west of Denver where the mountains meet the plains. I had lived in my house on Cascade Ridge Drive for 5 years, and every winter I parked my fishing boat and small camping trailer on the side of my property, right where I always had since moving in. The property stretched back about half an acre, and there was a gravel pad near the rear property line that the previous owner had installed specifically for storing vehicles and equipment during the off-season. The location made perfect sense because it kept the boat and camper out of sight from the street, tucked behind some blue spruce trees that provided excellent screening. That morning, I was winterizing the boat when I heard the clicking of high heels on my driveway. I looked up to see Patricia Donovan, the president of our homeowners association, marching toward me with a clipboard clutched to her chest like a shield. She was about 50 years old with that haircut. You know, the one, where it's short in the back and longer in the front, dyed an unnatural shade of blonde. She wore a puffy vest over a turtleneck despite the mild temperature, and her lips were pressed into a thin line of disapproval. "Mr. Edwards," she called out, not bothering with a greeting. "I need to speak with you about those." She jabbed a manicured finger at my boat and camper. "Good morning, Patricia," I said, wiping my hands on a rag. "What about them?" "They're in violation of the HOA covenants," she said, flipping through papers on her clipboard. Section 7, Paragraph 3 clearly states that no recreational vehicles, boats, or trailers may be stored on any lot in a location visible from neighboring properties or common areas. I gestured at the thick line of spruce trees. "They're not visible from anywhere. I made sure of that when I put them here. You can't see them from the street, and the trees block the view from the Henderson's place next door." Patricia's nostrils flared. "I can see them from the walking trail." She was referring to the community trail that ran along the rear of the properties in our section. The trail was popular with joggers and dog walkers, winding through the development and connecting to the larger county trail system. "The trail is on an easement," I said. "It's for access and utilities, not for determining what's visible. Besides, I've had these here every winter since I bought the house. Nobody's ever complained." "Well, I'm complaining now," Patricia said. "As HOA president, it's my responsibility to enforce the rules equally for everyone. You have 2 weeks to remove them or face fines of $100 per day per violation." My jaw tightened. $200 a day? That's insane. Where am I supposed to put them? Storage facilities cost a fortune, and I use them regularly for weekend trips. "That's not my problem," Patricia said, already turning to leave. "The rules are the rules, Mr. Edwards. 2 weeks. I stood there watching her walk away, anger building in my chest. The whole interaction felt arbitrary and petty, but I dealt with HOAs before and knew that fighting them was often an exercise in futility. Still, something about this didn't sit right with me. That evening, I pulled out my copy of the HOA covenants and read through Section 7 multiple times. Patricia was technically correct that the language prohibited storage of recreational vehicles visible from neighboring properties or common areas. But the more I thought about it, the more I questioned whether the trail actually qualified as a common area in the legal sense. The trail existed on an easement granted to the county and the HOA for access and utility purposes. It wasn't owned by the HOA. It was an easement over private property that included my backyard. I called my neighbor, Frank Henderson, who had lived in the development since it was built in 2004. Frank was in his 70s, a retired civil engineer who loved to talk about property law and zoning regulations. "Frank, it's Paul Edwards from next door. Got a minute?" "Sure, Paul. What's going on?" I explained the situation with Patricia and the storage ban. Frank listened quietly, then let out a low whistle. "That trail's been a source of controversy from the beginning," he said. "When the developer built this place, they had to grant easements to the county for the trail system as part of the approval process. The easement runs across everyone's back property line. We still own that land. The easement just gives the county and HOA the right to maintain the trail and access utilities. So it's not technically a common area?" I asked. "Not in my understanding. A common area would be something the HOA owns, like the clubhouse or the playground. The trail easement is different. But I'm not a lawyer, Paul. You might want to talk to one." I thanked Frank and hung up, my mind racing. If the trail wasn't a common area, then Patricia's interpretation of the covenant might be wrong. My boat and camper weren't visible from any neighboring property or any actual common area. The only place you could see them from was the trail, and if the trail was just an easement across my property, that changed everything. The next morning, I drove to downtown Lakewood and met with an attorney named Richard Morrison, who specialized in real estate and HOA disputes. His office was in a converted Victorian house, and he greeted me wearing khakis and a button-down shirt with no tie, which immediately put me at ease. "Tell me what's going on," Richard said, leaning back in his chair. I laid out the whole situation, including Frank's insight about the easement. Richard took notes and asked several clarifying questions about the exact location of my storage area, the width of the easement, and how long I'd been using the space. "This is interesting," Richard said when I finished. "If the trail is on an easement rather than HOA-owned land, then it's not a common area under Colorado law. An easement is simply a right to use someone else's property for a specific purpose. The property owner retains ownership and all rights that don't conflict with the easement use." "So Patricia's wrong?" I asked. "Potentially. But it's more complicated than that. Even if she's wrong about the covenant violation, the HOA might argue that your storage interferes with the easement purpose. We need to look at the exact language of the easement grant and the covenants." "What should I do?" Richard steepled his fingers. "First, let me pull the property records and review all the relevant documents. That'll cost you about $500 for my time. Once I've done that analysis, I can give you a better sense of your options. But I'll tell you right now, if you decide to fight this, it could get expensive and time-consuming. HOAs don't like to back down, especially when a board member's ego is involved." I thought about the alternative, paying thousands for winter storage every year or selling my boat and camper entirely. Neither option appealed to me. "Do the review," I said. "I want to know where I stand." Richard nodded. "I'll have something for you in a week." In the meantime, I moved the boat and camper to a friend's property outside the HOA's jurisdiction. I didn't want to give Patricia any ammunition by ignoring her deadline, even though I planned to challenge her decision. My friend Mike lived in unincorporated Jefferson County on 5 acres, and he had plenty of room. Still, the drive was 45 minutes each way, which meant using my boat for weekend fishing trips became much more complicated. True to his word, Richard called me a week later with his findings. "Paul, I've got good news and bad news. The good news is that you're right. The trail is on an easement, not common area land. The easement was granted in 2003 when the development was platted, and it specifically allows for pedestrian trail access and utility maintenance. Nothing in the easement language restricts property owners from using their land adjacent to the easement as long as it doesn't interfere with those purposes. What's the bad news? I asked. The bad news is that the HOA covenant language is broad enough that they might still claim a violation. Section 7 doesn't define common areas, and they could argue that the term should include easements. A court might side with either interpretation. So what do? I recommend you file a formal appeal with the HOA board, point out the easement issue and request that they reconsider. If they deny the appeal, then we can decide whether to take it to court. But an appeal is required before you can sue anyway, so it's the logical first step. Richard helped me draft an appeal letter that laid out the legal arguments in clear terms. I cited Colorado property law, referenced the specific easement language, and argued that my storage didn't interfere with the trail or utility access in any way. I submitted the appeal to Patricia by certified mail, feeling a small sense of satisfaction at having a solid legal footing. 3 weeks later, I received the HOA board's response. Patricia had scheduled an appeal hearing for a Tuesday evening in January at the community clubhouse. I was required to appear in person to present my case. The night of the hearing was bitterly cold, with temperatures hovering around 15 degrees. I arrived at the clubhouse at 7 o'clock sharp, carrying a folder with photos of my property, copies of the easement documents, and Richard's legal analysis. The clubhouse was a modest building with a kitchen, a large meeting room, and a few offices. The board sat at a folding table at the front of the room, Patricia in the center, flanked by 4 other board members I recognized from neighborhood events. About a dozen other residents sat in the audience, apparently there to watch the proceedings. I recognized a few faces, including Frank Henderson, who gave me an encouraging nod. "Mr. Edwards," Patricia said formally, "you've requested an appeal of the board's determination that your boat and camper storage violates HOA covenants. You have 15 minutes to present your case." I stood and walked to the front, trying to keep my voice calm and professional. I explained the easement situation, showed photos demonstrating that my storage area wasn't visible from any neighboring property, and argued that the covenant language didn't apply to easement land. The trail is not a common area, I concluded. It's an easement across private property. My use of my own land doesn't violate any covenant as long as it's not visible from actual common areas or neighboring properties, which it isn't. Patricia barely looked at the materials I'd laid out. "Does anyone else have questions for Mr. Edwards?" One of the other board members, a man named Tom, raised his hand. "Have you had the boat and camper there in previous years?" "Yes, every winter since 2016 when I bought the house." "And no one complained before?" "That's correct." Tom nodded and made a note. The other board members asked a few clarifying questions, but Patricia remained stone-faced throughout. "Thank you, Mr. Edwards," Patricia said. "The board will deliberate and provide a written decision within 10 days. I gathered my materials and returned to my seat, frustrated that Patricia seemed to have already made up her mind. Frank caught up with me in the parking lot. "You made a strong case," he said. "Tom looked interested in what you were saying." "Patricia is going to deny it no matter what," I said. "Probably. But you've got the other board members thinking. That might matter." Sure enough, 8 days later I received a letter from the HOA board. The appeal was denied by a vote of 3-2. Patricia had written the decision herself, and it was filled with circular reasoning that basically boiled down to, "We say the trail is a common area. Therefore your storage violates the covenants." There was no engagement with the legal arguments about easements, no acknowledgement of the property records, nothing. I called Richard immediately. They denied it. Now what? Now we decide if you want to sue, Richard said. My honest assessment is that you have a strong case, but litigation is expensive and time-consuming. We're probably looking at 18 months to 2 years if it goes all the way through trial and appeals. My fees would be in the range of $15,000 to $25,000, maybe more depending on how hard the HOA fights. I felt sick. That's more than the boat and camper are worth combined. I know. That's why most people don't fight HOAs, even when the HOA is wrong. They're counting on you to give up because the cost isn't worth it. I sat in silence for a long moment. Part of me wanted to let it go to save the money and hassle, but another part of me was furious at the injustice of it. Patricia was wrong legally and factually, and she was using her position to bully me into compliance. Let's do it, I said. File the lawsuit. You're sure? I'm sure. This isn't just about the boat anymore, it's about the principle. Richard filed the complaint in Jefferson County District Court in February 2022. The lawsuit named the HOA as the defendant and sought a declaratory judgment that my storage didn't violate the covenants, an injunction preventing the HOA from fining me, and damages for the cost of moving my property and the legal fees I'd already incurred. The HOA hired a law firm from Denver to defend them, and the fight was on. Over the next 6 months, we went through the discovery process, exchanging documents and taking depositions. Patricia's deposition was particularly memorable. She sat across from Richard in a conference room, her lawyer beside her, and proceeded to dig herself into a hole. Mrs. Donovan, when you determined that Mr. Edwards' storage violated the covenants, did you review the easement documents? Richard asked. I don't need to review easement documents. I know the rules. But the easement defines the nature of the property interest. Didn't you think that was relevant? The trail is part of our community. That makes it a common area. But the HOA doesn't own the land under the trail, correct? Patricia shifted uncomfortably. We have the right to maintain it. That's because of the easement. But the property owners still own the land, don't they? I suppose technically, but yes or no, Mrs. Donovan, do the property owners still own the land under the trail? Yes, she admitted grudgingly. And in the 5 years before you issued the violation notice, Mr. Edwards stored his boat and camper in the same location every winter, correct? I wasn't aware of it before. But other board members were aware, weren't they? And no one considered it a violation until you became president. Patricia's face reddened. I take my responsibilities seriously. Previous boards may have been lax in enforcement. The deposition went on for hours, and Patricia's answers became increasingly defensive and contradictory. Richard was building a solid record that the HOA's interpretation was arbitrary and inconsistent with the actual property rights. The case went to trial in September 2022. Judge Barbara Whitfield presided, a no-nonsense woman in her 60s with a reputation for cutting through nonsense. The trial lasted 3 days, with each side presenting expert witnesses on property law and HOA governance. My expert, a law professor from the University of Denver, testified that easements are legally distinct from common areas, and that the HOA's interpretation conflicted with established Colorado property law. The HOA's expert, a consultant who worked primarily for HOA management companies, argued that the covenant language was broad enough to include easements and that the HOA board had discretion in interpreting the rules. I took the stand on the second day and explained how I'd used the storage area for years without any issues, how I'd moved the boat and camper in good faith when Patricia issued the violation, and how the whole situation had cost me time, money, and peace of mind. Mr. Edwards, Richard asked, why didn't you just accept the violation and move on? Because it's not right, I said. I'm not breaking any rules. The HOA is misinterpreting the covenants and they're doing it selectively. There are other people in the neighborhood who have storage situations that could be challenged, but Patricia singled me out. This isn't about enforcing rules fairly. It's about control. Patricia's lawyer, a sharp-dressed man named Gerald Foster, cross-examined me aggressively, trying to paint me as a rule breaker who thought he was above the covenants. But I stuck to my points, keeping my answers factual and calm. When Patricia took the stand, Richard methodically took apart her justifications. He got her to admit that she'd personally disliked the appearance of boats in the neighborhood and had made enforcing storage restrictions a priority when she became president. He also got her to concede that the board had never formally defined common areas in any policy document, and that her interpretation was based on her own opinion rather than any legal analysis. Judge Whitfield asked pointed questions from the bench, clearly skeptical of the HOA's position. When Gerald tried to argue that the board deserved deference in interpreting its own covenants, the judge cut him off. "Mr. Foster, this isn't about deference to the board's interpretation. This is about whether the covenants, as written, prohibit what Mr. Edwards was doing. The easement issue is a legal question, not a policy question. The board doesn't get to redefine property rights." Gerald sputtered a bit but recovered. "Your Honor, the covenants give the board broad authority to determine violations. That's standard in HOA governance." "Broad authority doesn't mean unlimited authority," Judge Whitfield replied. "Continue your argument." When the trial concluded, Judge Whitfield took the case under advisement, promising a decision within 60 days. Those 2 months were agonizing. I tried to focus on work, on my normal life, but the lawsuit hung over everything. Richard was optimistic, but he cautioned me that judges could be unpredictable and that we should be prepared for any outcome. The decision arrived in November 2022, almost exactly 1 year after Patricia had first confronted me about the storage. Richard called me as soon as he got the order. "We won," he said, and I could hear the smile in his voice. "On everything." Judge Whitfield's ruling was 32 pages long and methodically dismantled the HOA's arguments. She found that the trail easement was legally distinct from a common area, that the covenant language didn't prohibit storage that was only visible from easement land, and that the HOA had acted arbitrarily by enforcing a rule that hadn't been applied consistently in the past. She issued an injunction preventing the HOA from fining me for the storage and awarded me $15,000 in damages and legal fees. I felt a surge of vindication mixed with exhaustion. We'd won, but it had taken a year of my life and a significant financial investment even with the fee award. Richard had already billed me close to $20,000, and the HOA would reimburse most but not all of that. "Congratulations," Richard said. "This is a great outcome. Is it over?" I asked. "They can appeal, but I don't think they will. This decision is pretty definitive, and appeals are expensive. Most HOAs would cut their losses at this point." Richard was wrong. 2 weeks later, I received notice that the HOA was appealing to the Colorado Court of Appeals. Patricia, it seemed, was not willing to accept defeat. The appeal brief argued that Judge Whitfield had erred in her interpretation of the covenants, and that she'd given insufficient weight to the board's discretionary authority. I was furious. "They're just trying to bleed me dry." "This is personal for Patricia." "Probably," Richard agreed, "but appeals can also backfire. If the Court of Appeals affirms, it creates binding precedent that will help other homeowners in similar situations. The HOA might be shooting itself in the foot. How long will an appeal take?" "Another 12 to 18 months, most likely." The good news is that the appellate work is less expensive than trial work. We're mostly writing briefs and presenting oral arguments. I'd estimate another $8,000 to $10,000 in fees. I authorized Richard to defend the appeal, feeling like I'd been pulled back into a nightmare I thought was over. The HOA's appeal brief was filed in January 2023, and Richard had 60 days to respond. His response brief was a thing of beauty, systematically addressing each of the HOA's arguments and showing how Judge Whitfield had correctly applied the law. The case was assigned to a 3-judge panel, and oral arguments were scheduled for August 2023 in the Ralph L. Carr, Colorado Judicial Center in Denver. Richard and I met outside the courthouse on a warm summer morning, both of us wearing suits and carrying leather folders. "Ready?" Richard asked. "As ready as I'll ever be." The courtroom was formal and intimidating, with high ceilings and dark wood paneling. The 3 judges sat at an elevated bench, Judge Maria Alvarez in the center, flanked by Judge Thomas Reid and Judge Cynthia Tran. They were all in their 50s or 60s, with decades of judicial experience between them. Gerald Foster argued first for the HOA, contending that the trial court had substituted its judgment for the board's, and that HOA covenants should be interpreted broadly to give boards flexibility in enforcement. Judge Alvarez interrupted him within minutes. "Mr. Foster, isn't the fundamental problem here that your client is trying to restrict what Mr. Edwards does on his own property based on visibility from an easement? How is that different from saying a property owner can't use his land because someone might see it while trespassing?" "It's not trespassing, Your Honor. The easement grants lawful access. For specific purposes," Judge Alvarez said, "pedestrian trails and utility maintenance. Does that easement give the public any right to control what the property owner does on the rest of his land?" "The covenants give that right to the HOA," Gerald responded, "but only if the storage is visible from common areas or neighboring properties," Judge Tran interjected. "The trial court found that the easement isn't a common area. Are you disputing that factual finding or the legal conclusion?" Gerald tried to argue both, which seemed to frustrate the judges. They pressed him on the distinction between easements and ownership, on whether the board had acted consistently, and on what limiting principle would prevent the HOA from restricting any activity visible from any easement. When Richard's turn came, he was calm and clear, walking the judges through the property records and the specific covenant language. He argued that affirming the trial court would provide clarity for homeowners throughout Colorado who faced similar issues. "Easements are everywhere," Richard said. "Utility easements, access easements, drainage easements. If HOAs can restrict property use based on visibility from easements, it essentially gives them veto power over large portions of every lot. That's not what the covenants say, and it's not what Colorado property law allows." Judge Reid asked, "What if the covenant explicitly included easements in the definition of common areas? Would that change your analysis?" "It would, Your Honor, but this covenant doesn't do that. It uses common areas without definition, and under Colorado law, that term has a specific meaning that doesn't include easements over private property. The HOA is asking this court to rewrite the covenants to say something they don't say." The oral arguments lasted about 45 minutes, and when they concluded, the judges thanked both lawyers and took the case under advisement. Richard and I walked out of the courthouse into the bright August sunshine. "How do you think it went?" I asked. "I think we're in good shape," Richard said. The judges seemed skeptical of the HOA's arguments, especially Judge Alvarez, but you never know for sure until the opinion comes out. The wait was excruciating. Appellate decisions can take months, and every day I checked the court's website for updates. Meanwhile, I'd moved my boat and camper back to Mike's property and was paying him a nominal monthly fee for the space. The entire situation felt absurd, a massive legal battle over where I could park my own belongings on my own land. In December 2023, more than 2 years after Patricia had first confronted me, I got the call from Richard. The Court of Appeals issued its opinion. We won, Paul, unanimously. I sat down heavily, overwhelmed with relief. Tell me everything. The opinion is written by Judge Alvarez, and it's a complete vindication. She affirms Judge Whitfield on every point and goes even further. The court holds that easements are categorically different from common areas under Colorado law, and that HOA covenants can't restrict property use based solely on visibility from an easement, unless the covenant explicitly says so. The court also found that the HOA violated your easement rights by trying to control your use of land adjacent to the easement. Wait, easement violation? That wasn't part of our original case. Judge Whitfield touched on it, but the Court of Appeals expanded the analysis. They held that by threatening fines to prevent you from using your property near the easement for lawful purposes, the HOA exceeded the scope of the easement rights. An easement only grants specific limited rights. It doesn't give the easement holder control over the property owner's other uses of the land. The court found that the HOA's actions interfered with your property rights. What does that mean practically? It means you're entitled to additional damages beyond what Judge Whitfield awarded. The Court of Appeals is remanding the case back to the district court for a new damages hearing specifically on the easement violation claim. I felt a strange mix of vindication and exhaustion. We'd won, decisively, but now there was another hearing to determine damages. How much more? I asked. Hard to say. You can claim the cost of alternative storage for the entire period, additional legal fees, and potentially compensation for the interference with your property rights. We're probably looking at another $20,000 to $30,000 in damages, maybe more. The HOA had 45 days to petition for rehearing or seek review by the Colorado Supreme Court. Patricia must have finally seen the writing on the wall because the deadline passed without any further action. The case was officially over except for the damages hearing. That hearing took place in March 2024 in front of Judge Whitfield again. Richard presented evidence of all my costs. The storage fees I'd paid Mike, the additional mileage and time spent transporting the boat and camper for weekend trips, and the legal fees that hadn't been covered by the original award. He also argued that I deserved compensation for the interference with my property rights, citing Colorado cases that recognized such damages. The HOA's lawyer, a different attorney this time since Gerald had apparently moved on, barely put up a fight. The HOA was reeling from the appellate decision and seemed eager to end the litigation. Judge Whitfield awarded me $38,000 in additional damages, plus interest and costs. When the final judgment was entered in May 2024, the total amount the HOA owed me was over $55,000. Richard's total fees had been around $32,000, which meant I'd net about $23,000 after paying him. More importantly, I'd established a legal precedent that would protect other homeowners from similar overreach. I moved my boat and camper back to my property in June 2024, parking them in the exact same spot where this whole saga had begun. Frank Henderson came over with a bottle of bourbon to celebrate. "You did it," Frank said, raising his glass. "You beat the HOA and changed the law." "I still can't believe it took 3 years," I said. "Was it worth it?" I thought about that question seriously. The lawsuit had consumed enormous time and energy. It had stressed me out, cost me sleep, and made me somewhat of a pariah among the HOA loyalists in the neighborhood. But it had also shown me that principles matter, that standing up to bullies is important even when it's expensive and difficult. "Yeah," I said, "it was worth it." Patricia Donovan resigned as HOA president in July 2024, shortly after the final judgment. Rumor around the neighborhood was that the HOA's insurance company had forced her out after paying the judgment, concerned about further liability if she continued making arbitrary decisions. The new board president, Tom, the same board member who'd asked thoughtful questions at my appeal hearing, reached out to apologize for the whole mess. "We should have listened to you from the beginning," Tom said. "Patricia was on a power trip and the rest of us didn't push back hard enough." "I appreciate that," I said. "What's the board going to do differently going forward?" "We're revising the covenant interpretation policies to make sure we're not overstepping our authority. We're also implementing a rule that any violation notice has to be reviewed by an attorney before it's issued, specifically to avoid the kind of mistakes we made with you. And we're creating a neutral appeal process that doesn't involve the same board members who issued the violation in the first place." Those changes seemed reasonable, and I told Tom I supported them. The HOA even published a newsletter article explaining the court decisions and what they meant for residents, which I thought showed genuine institutional learning. As fall approached and I prepared to winterize my boat again, I felt a deep sense of satisfaction looking at it parked safely on my property. The gravel pad had never looked better. I'd even added some additional landscaping around it, planting native grasses that would fill in over time and provide even more screening, not because I had to, but because I wanted to. One October evening, I was washing the boat when I saw a young couple walking on the trail behind my property. They stopped and looked at my setup, and I tensed slightly, old instincts kicking in. But then the man gave me a thumbs up and called out, "Nice boat." I waved back, grinning. "Thanks." They continued on their walk, and I returned to my work, finally at peace with my property and my place in the community. The legal precedent from my case had already been cited in 2 other HOA disputes in Colorado, both times resulting in homeowners successfully defending their property rights against overreaching associations. Richard told me it was becoming an important case in HOA law, studied in Colorado law schools and referenced by attorneys throughout the state. The financial impact on the HOA was significant enough that the association had to raise dues to replenish its reserves after paying the judgment. Some residents complained about the increase, and Patricia reportedly left the neighborhood entirely, moving to another development in Aurora. I felt no particular satisfaction about her departure, just a sense that justice had been served. In November 2024, I got a letter from a homeowner in Fort Collins who was facing a similar situation with her HOA. She'd read about my case in a news article and wanted advice on how to proceed. I spent an hour on the phone with her, sharing what I'd learned about easements, property rights, and the importance of standing firm when you know you're right. I also referred her to Richard, who I knew would give her good counsel. The experience transformed my understanding of property ownership and community governance. I'd always thought of the HOA as a necessary nuisance, an organization that maintained common areas and enforced basic standards. I'd never imagined it could become an adversary, or that defending my rights would require years of litigation. But I'd also learned that the legal system, for all its flaws and delays, could ultimately deliver justice. That winter, my boat and camper sat exactly where they'd always belonged, on my property behind the trees, visible only from the easement trail where occasional walkers might glance at them without complaint. The appeals court decision hung framed in my garage, a reminder that persistence and principle can triumph over bureaucratic overreach. Patricia never apologized or acknowledged that she'd been wrong. I didn't expect her to. People like her rarely admit mistakes, preferring instead to retreat and find new targets for their need for control. But the law was now clear, in Colorado at least, that HOAs couldn't use easements as a pretext to restrict property owners' reasonable use of their own land. The case had ripple effects beyond just HOA law. The Court of Appeals decision clarified easement rights more broadly, which helped property owners dealing with utility companies and municipalities that sometimes tried to expand easement rights beyond their proper scope. Several property rights organizations contacted me to thank me for pursuing the case and offered to help publicize the decision to ensure other homeowners knew about their rights. Looking back on those 3 years from November 2021 to May 2024, I felt a complex mix of emotions. Pride that I'd stood up for my rights, frustration that it had been necessary at all, gratitude for Richard's excellent legal work and for friends like Frank and Mike who'd supported me throughout, and hope that my experience would make things easier for others facing similar battles. The story made its way around the neighborhood in various forms, some accurate and some embellished. I became known as the guy who'd beaten the HOA, which carried a strange sort of celebrity. Some people avoided me, perhaps worried I was litigious or difficult. Others sought me out for advice on their own disputes with the association, or to share their frustrations with Patricia's tenure as president. I tried to be gracious with everyone, emphasizing that I hadn't wanted to sue the HOA and that I hoped the reforms Tom was implementing would prevent similar conflicts in the future. I had no desire to be at war with my neighbors or to create ongoing antagonism. I just wanted to use my property as I'd always used it, reasonably and legally. As 2025 began, life returned to a comfortable normalcy. I took the boat out fishing on cold January mornings when the lakes were quiet and the fish were biting. I planned camping trips for the spring, knowing my trailer was right where I needed it, ready to hitch up and go. The legal battle had been exhausting and expensive, but it had also been clarifying. I knew now what I was willing to fight for, and how to navigate the systems that govern property and community. The $55,000 judgment from the HOA arrived in 3 payments as the association arranged its finances. The money more than covered my legal expenses and compensated me for the hassle and alternative storage costs. More valuable than the money, though, was the precedent and the principle. Property rights matter. Due process matters. HOAs are not above the law and cannot arbitrarily restrict homeowners based on misinterpretations of covenants and easements. Richard and I stayed in touch, occasionally meeting for lunch to discuss developments in HOA law. He told me the case had been great for his practice, bringing him several new clients who were facing similar issues with their associations. He was grateful I'd been willing to see the case through to the end rather than settling early, which many clients chose to do simply to end the stress. I sometimes wondered what would have happened if I just moved the boat and camper that first day when Patricia had confronted me. I'd have avoided years of legal stress, saved time and money in the short term. But I also would have surrendered my rights and encouraged the kind of arbitrary enforcement that makes HOA living miserable for so many people. More importantly, other homeowners would still be vulnerable to the same overreach, lacking the legal precedent that now protected them. The case taught me that justice often requires sacrifice and persistence. The system is designed in ways that favor institutions over individuals, with HOAs having insurance-funded legal defense while homeowners bear the costs personally. Many valid claims never get pursued simply because the financial and emotional burden is too high. I'd been fortunate to have the resources and support to see the fight through, and I felt an obligation to help others who might face similar situations. In late spring of 2025, I was invited to speak at a property rights seminar in Colorado Springs about my experience. I stood in front of about 60 people, mostly homeowners and a few attorneys, and told the story of how a simple dispute about boat storage had turned into a 3-year legal odyssey and a landmark appellate decision. The lesson isn't that you should always fight, I told the audience. Litigation is expensive and stressful, and sometimes the smart move is to compromise or walk away. But when the principle is important, when the HOA is clearly wrong, and when you have a solid legal foundation, it's worth standing up for your rights. You might not just help yourself, you might help everyone who comes after you. The audience asked thoughtful questions about easements, about finding good legal counsel, about managing the emotional toll of extended litigation. I answered as honestly as I could, sharing both the victories and the difficulties. Several people approached me afterward to share their own HOA horror stories and to thank me for setting a precedent they could use in their own situations. Driving home that evening, I thought about how strange and circuitous the path to justice had been. A confrontation in my driveway had led to appeals court arguments, from a local dispute to a statewide precedent, from personal frustration to public benefit. I hadn't set out to be an advocate or a test case. I just wanted to park my boat on my own property. But sometimes standing up for yourself means standing up for everyone. The boat and camper remained in their spot through the winter of 2025, undisturbed and unquestioned. The gravel pad became part of the landscape, as natural and unremarkable as it should have been from the beginning. Occasionally, I'd see walkers on the trail glance over at them, but no one complained, no one sent violation notices, no one questioned my right to use my own property in a reasonable way. Patricia's legacy was the opposite of what she'd intended. Rather than establishing strict control over storage and appearance, her overreach had resulted in a legal decision that limited HOA authority and clarified property rights in favor of homeowners. The case would be cited for years, maybe decades, as a check on HOA power and a reminder that covenants must be interpreted according to their actual language and applicable law, not according to board members' personal preferences. As summer arrived and I prepared the boat for fishing season, I felt genuine gratitude for how everything had turned out. Yes, it had been 3 difficult years. Yes, it had cost money and time and stress. But the outcome was right, the precedent was sound, and my property rights were secure. I'd learned that the legal system, despite its flaws, could work when you had patience, good counsel, and a solid case. The HOA under Tom's leadership had become more reasonable and transparent, implementing the reforms he'd promised and working collaboratively with residents rather than dictatorially. The association was functioning as it should have all along, maintaining common areas and enforcing reasonable rules without overstepping into micromanagement of private property. I never forgot the lessons of those years, that rights must sometimes be defended at cost, that institutions need checks on their power, that legal precedent shapes the possibilities for everyone who follows. My small dispute about winter storage had become part of Colorado legal history, a case that would help other homeowners stand up to overreaching HOAs and reclaim their property rights. and on quiet mornings when I loaded my fishing gear into the boat, preparing for a day on the lake, I felt a deep satisfaction knowing that I'd fought for what was right and won not just for myself, but for everyone who would benefit from the precedent we'd established. The appeals court had found the HOA guilty of easement violation and awarded damages, vindicating everything I'd argued from that first confrontation with Patricia in November 2021. Justice had been served, property rights had been clarified, and my boat sat exactly where it belonged, on my land, bothering no one, protected by law and precedent from arbitrary HOA overreach. The story had a proper ending after all, one that made the 3-year struggle worthwhile and demonstrated that sometimes, when you stand firm on principle, the system delivers the right result.